Okay, so good afternoon. Today I would like to discuss the case of third gender recognition in Nepal as a lens for wider question about minority rights within Hindu constitutionalism. So the title proposes a deliberately uneasy alternative. Is constitutional recognition best understood as a neoliberal emancipation, meaning inclusion achieved through globally legible rights, individual autonomy, privacy, and administrative identity? Or is it better read as a turn to tradition, meaning a constitutional gesture that recovers, reauthorizes, or redescribes forms of plurality that were culturally legible before modern legal codifications narrowed them down? My argument is that Nepal's third gender jurisprudence sits between those poles, and that the tension is structural rather than incidental. It is produced by distinctive constitutional style that is outward-looking and right-centered, but also selectively pluralist. The court borrows aggressively from international and comparative sources to correct perceived injustice. Yes, it is also less consistent in engaging with Nepal's own internal normative plurality with the same depth. So, I would like to focus in my presentation on 6 steps. Namely, first, I will clarify what is at stake conceptually in the concept of third gender. Second, I will give a brief historical account of why distinction against gender and sexual minorities can be read as in part a product of modern legal state formation rather than timeless cultural constant. Third, I will analyze the case Pant versus Nepal as a constitutional moment, focusing on method, sources, and the rights grammar for the court adopted. Fourth, I placed Pant's case within a broader pattern in which the court alternates between correction of harmful customs and preservation of selected living institutions. Fifth, I return to the title question and argue that the settlement is emancipatory itself, but it risks neoliberalizing recognition because inclusion is channeled through bureaucracy and globally portable rights templates rather than internal plural law. And finally, I indicate what a more internally pluralist approach to minority rights might look like under Nepal's federal and post-2007 constitutional trajectory. So what are the key concepts? I will begin with the third gender. In the legal sense, at issue here, third gender refers to individuals who are legally categorized as neither men nor women. Socially, it also overlaps with South Asian histories of recognizing more than two gender categories. The legal categories intersect with an existing cultural vocabulary, even if imperfectly. That matters for the theoretical puzzle. In many Euro-Atlantic jurisdictions, recognition of gender diversity is often narrated as a break with tradition or the legal arrival of a new concept. Nepal complicates that narrative because third gender can be narrated simultaneously as a new state law and not new in cultural imagination. Now, minority rights. In Nepal, minority rights disputes have repeatedly been constitutionalized rather than left to ordinary politics. Nepal's modern constitutional history is marked by cycles of replacements and translation. Social mobilization has repeatedly pushed inclusion question into foundational texts, yielding a constitutional culture in which the constitution is programmatic and directional rather than merely constraining. Finally, Hindu constitutionalism in Nepal can be spotted through even though it formally ceased to be a Hindu kingdom and Nepal declared itself secular. Yet Hindu identity continues to shape social norms, including norms that structure gender, family, and respectability. The point is not that the constitution is Hindu in formal sense today, but that Hindu normative influence remains a powerful background condition for constitutional life. So, a core claim for the Nepali case is that discrimination can be chronologically linked to particular moments of legal modernization. Hindu narrative traditions contain figures and episodes that can be read as acknowledging gender plurality. I do not use this as simplistic evidence of historical tolerance. Rather, it destabilizes this assumption that tradition is always the origin of exclusion. The archive is complex, and the complexity matters because it opens room for non-linear accounts. The modern legal story in Nepal sharpens around 19th century codification. In the mid-19th century, Nepal consolidated comprehensive legal code, the Muluki Ain, promulgated in 1854 and remaining in force until 1963. The codification was shaped by European legal forms and by a state project of ordering society for a unified normative text. The key for my argument is that European-style legal form entered a polity without direct colonial rule, producing a distinct hybridity rather than a straightforward transplant. Within the codification, criminalization of certain forms of sexual conduct appears as a pivotal insertion. State violence becomes a mediator of sexuality and gender expression. Oppression is exercised through policing and through administrative systems that demand binary classification. This helps explain why rights recognition in Nepal often confronts not only social stigma, but state built to make certain identities illegible. So even before PANT, a structural decision, pension appears, the state may be both an agent of imported repression and an agent of rights-based reform. So, PANT case arises from concrete administrative problem. Nepal's citizenship card structures access to state benefits and documents such as passports and other forms of legal identity. Individuals who refused binary sex classification were effectively blocked from full participation because the system required identification as male or female. The petitioners argued that this deprived them of legal recognition and obstructed the exercise of fundamental rights. The state argued that existing arrangements were sufficient. This matters for the title question. Emancipation here arises through paperwork, through legibility to the state, and through access to mobility and welfare mechanisms. This is a recognizably liberal pathway of inclusion, and it can slide into neoliberal dynamic when recognition is reduced to administrative classification rather than substantive social equality. The court crystallized the dispute into three legal issues. First, whether characteristics of LGBTI persons should be treated, where here I stands in terms of intersex people, should some regional flavor to LGBT movements. LGBTI persons should be treated as natural variations or as mental perversion. That was the question for the court. Second, whether the state discriminated on the basis of sexual orientation or gender identity. Third, whether mandamus should be issued to protect and expand the scope of violated rights. So, the most striking features of PANT's judgment are methodological. The court assembled an unusually wide comparative and international repertoire, including UN human rights material, reports and expert meetings, NGO publications, and case law from multiple jurisdictions. These materials are not decorative. They shape definitional work and support the court's view that sexuality and gender diversity are not illnesses but natural variations. A key feature is the sequencing. Court builds a comparative scaffold and only then pivots to domestic constitutional provisions, such as equality, rejection of discriminatory laws, and social justice. This sequence suggests that what counts as progressive constitutional law is partly validated externally and then translated into domestic constitutional idiom. So, PANT ends with an expansive rights claim. The court affirms that fundamental rights applied to citizens identifying as LGBTI recognize as rights to free cohabitation for adults and compels the government to implement a third gender category in administrative terms. It also encourages legislative attention to discrimination and urges engagement with evolving international standards when designating reforms. The emancipatory content is real, but limits appear at the same time. First, the primary mechanism is administrative recognition. Legal inclusion is delivered through state categories and documentation, which means that the state remains the central gatekeeper of personhood. Second, the comparative gaze is directed outward. The jurisprudence is rich in transnational rights grammar, but it is thinner and sustained engagement with Nepal's internal normative plurality, including how local perspective might already accommodate, contest, or complicate gender diversity. The consequence is a recurring implementation gap, where rights exist formally yet remain unevenly realized in everyday institutional life. So, why this looks neoliberal? The return to the title, to return to the title and consider why we are using the words neoliberal here as a plausible reading, we should first bring up that the practical motor is administrative inclusion. The pathway to dignity runs through state legibility, citizenship, documentation, access to mobility, and welfare regime. Recognition becomes an entitlement to be correctly classified by the state, so that one can participate in institutional life. Second, the doctrinal architecture leans heavily on privacy and equal treatment logics derived from transnational jurisprudence. This is rights language that travels easily and fits the grammar of global liberal constitutionalism. Third, the remedial imagination tends towards governance through expertise and international standards. This can be emancipatory, but it also risks turning recognition into compliance with external templates rather than the articulation of locally rooted pluralism. Finally, where social stigma and bureaucratic discretion remain strong, formal recognition can coexist with institutional harassment and uneven implementation, producing inclusion on paper without reliable protection in practice. So, and why at the same time it can look traditional. So now let's discuss the other side. There are reasons why pant can also be read as a term to tradition, though not as nostalgia. First, the cultural intelligibility of gender plurality complicates the claim that recognition is purely Western import. Even when historical materials are ambivalent, they can provide internal normative resources for resisting the idea that plurality is alien. Second, the historical narrative suggests that certain forms of repression were intensified through modern codification and steric ordering. If discrimination is partly a product of legal modernity, then recognizing third gender can be read as undoing a prior narrowing of social categories. Third, a sociological account of law highlights a legitimacy problem, where state legal form is out of sync with living normative orders, compliance can be weak and rights can remain performative rather than effective. That does not imply that human rights are wrong. It implies that constitutional reasoning must do serious internal translation work if rights are to become socially anchored. Quick implications. First, method Nepal's Supreme Court demonstrates extraordinary capacity to borrow outwardly, but a more robust constitutional pluralism requires an inward comparative sensibility. Internal normative orders should be treated as serious constitutional material rather than as a residue, folklore, or merely a target for reform. Second, design in Nepal design-wise in Nepal, emancipatory claims frequently become constitutional claims. Minority rights disputes are therefore also disputes about foundational architecture and about how the state imagined membership under federalism and secularism. Finally, substance. Administrative recognition is necessary, but not sufficient. A third gender category in identity documents can enable access to services, but it does not by itself dismantle institutional harassment, social exclusion, or economic precarity. A thicker constitutional approach would link recognition to enforceable protections, remedies, and material conditions of equal citizenship. So, to return to the title, Nepal's third gender recognition is best understood as constitutional weaving of diversity into state fabric that is secular in form, Hindu in social imagination, outward-looking in judicial method, and uneven in implementation. The analytical task here is to track how emancipation and tradition are co-produced dialectically, and to ask what kinds of pluralism and constitution enables and what kinds it merely names. Thank you, and I look forward to your questions.